Directives Principle of State Policy, Part 4th of the Constitution, Article 36 to 51, contents of the Directives of Principle of State Policy, classification of the directives as shown in the table 4th. These principles may be classified under the several groups. Certain ideals, particularly economic, which are the according the framer of Constitution, state should be strive for the certain direction to the legislature, executive intended to show in what manner of state should be exercised these legislative and executive powers. The certain rights of citizen which shall be enforceable by the court, like the fundamental rights are, but which is the state shall nevertheless aim to securing by the regulation its legislative and administrative policy. It shall be duty of the state to follow these principles both in the matter of administration as well as in the making of laws. These embodies the object of a state under the Republican Constitution, namely that it to be a welfare state and not mere police state. Most of these directives will be seen aimed to establishment of the economic and social democracy, which is the place for the preamble. According to Sir Edward Jennings, the philosophy underlying most provision in the Fabian socialism without the socialism for only the nationalism of the means of production, distribution, and exchange is missing. Nature of economic democracy envisaged. In nature of economic democracy envisaged, this is much clear. However, our Constitution as framed the 1949 did not adhere any particular ism, but sought to effect a comparative between individualism and socialism by eliminating the vices of unbridled private enterprise and state interest of social control and welfare measures as far as possible. Socialistic pattern of society. This is why socialistic pattern of society, not a socialism, was clear to be the objective or planning by the Pandit Nehru. Socialism is some people means two things: distribution, which means cutting of the pockets of the people who have too much money, and nationalization. Both these are desirable objective, but neither is by itself socialism. Any attempt to attribute to affecting the proactive machinery utterly wrong to do who would be weaken observe. The basis of socialism is greater wealth. There cannot be socialism of poverty. Therefore, the process of equalization has been phased. Secondly, there in the question of nationalism, I think it is a dangerous merely nationalize something without being prepared to work it properly. To nationalize, we have to select things. My idea of socialism is that my individual in the state should be have equal opportunity for progress, trends towards collectivism. It must be mentioned in the context that the governmental policy at the union level and had demonstration to greater bias toward collectivism during the regime of Dr. Mr. Indira Gandhi. To quite a number of industries, trades, and other means of production were nationalized during 3 decades since the independence, either directly through the agency or state-owned, state-controlled operation. Banking, insurance, and aviation, coal mines. 42nd Amendments. It should, however, mention that though the objective of state has been described to the socialist by the amendment of the preamble by the Constitution 42nd Amendment Act, Mr. Indira Gandhi had said this, that is the socialism did not indicate the collectivism but the offering the equal opportunity to all through the socio-economic reform. By the some amendments, certain other changes has been introduced. The part 4th, adding new directives to accentuate the plus the socialist wise of the Constitution. Article 39A has been inserted to rejoin the state to provide free legal aid to the poor and to take legal suitable steps to ensure equal justice to all, which is the offered by preamble. Article 43A has been inserted in order to direct the state to ensure the participation of worker in management, industries and other undertaking. This is what a non-profit sharing. This is appropriate step to advancement of socialism in the sense of economic justice. 44th Amendment. The Janta government sought implemented the promise of economic justice and equality of opportunity ensured by the preamble by inserting clause 2 in Article 38 by the 44th Amendment Act 1948 as follows: the state shall be particularly strive to minimize inequalities in income and endeavour to eliminate Inequalities in state facilitate to opportunity not only among the individual but also amongst the people of group of people residing in different areas of engage in different vocations. In innocently looking amendments is to read along with the elimination of fundamental rights and property. These together have paved the way for the confiscatory taxation and equalizing salaries and wages for the different vocation and different category of work, which would users a socialistic society even without resorting nationalism as the mean of production. The Article 38 resolving the state to strive to promote the welfare of the people by the securing and protecting effectively as it may the social order in which justice, social, economic, and political shall inform all institutions and national life. It direct to state to strive minimize inequality income and in order to eliminate inequality of status, facilitate and opportunity among the individuals and group of people residing in different areas or engaged in different vocation. The 86th Amendment, the Constitution 86th Amendment Act 2002 alterated Article 45 making provision for clearly childhood care and education for children below the age of 6 years in place of the erstwhile provision for free and compulsory education until age of 14 years. 97th Amendment Act, the Constitution 97th Amendment Act 2011 has inserted Article 43 in Part 4th of the Constitution to promote the voluntary formation of cooperative society. Article 43 provides that the state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. The Constitution 97th Amendment Act was passed in the year of 2011. The Amendment Act received the presidential assent on the January 2012 and come into force with effect from 15 January 2012. In the recent judgment, the Union of India and Rajendra and Shah, the Supreme Court is struck down the most part of the Constitution 97th Amendment Act, the ground that is acquired ratification by the last one half of the state legislature as per the Article 368 of 2 of the Constitution. The directives, however, differ from the fundamental rights contained in Part 3rd of Constitution or the ordinary law of the land in the following respect. Directives compared with the fundamental rights. While the fundamental rights constitute the limitation upon the state action, the directive principles are in nature of instrument or instructions to the government of the day to certain things and to achieve certain ends by their action. The directives however require the implemented by the legislation and so long as no law carrying out the policy laid down the directives, neither the state nor the individual can violate any existing law legal right under the color of following a directive. Non-judiciability. The directives are not enforceable in the court and the not create any justiciable right to in favor of individuals. From the standpoint of individual, the differences between the fundamental rights and the directives in that between the judiciable and non-judiciable rights, a classification which has been adopted by a framer of our Constitution from the Constitution of the year. Thus, though a directive under the Article 43 rejoins the state to secure a living wage to all workers, no worker can secure a living wage by means of the action in a court, so long as it not implemented by the appropriate legislation. In other words, the court are not competent to compel the government to carry out any directives to provide to free compulsory education within the time limit of Article 45 or the undertake the legislation to implement any of the directives principle. It may observe that the declaration made it Part 4th of the Constitution under the head directives or principle of the state policy are the may cases of the wider import than the declaration made it Part 3rd of fundamental rights. Hence, the question of priority in case of conflict between the two classes provision may easily arise, but while the fundamental rights are enforceable by by the court Article 32 and 2 to 6, and the court bound to declare as void any law that the consistent with any of fundamental rights. The directives are not enforceable by the court Article 37, and the court cannot be declared as void any law in otherwise valid on the grounds that the contravenes any of the directives. Hence, in case of any conflict between parts 3rd and 4th of the Constitution, the former shall prevail all in the courts. The foregoing general proposition laid down by the Supreme Court in 1951 must now, however, to be read subject to major exception. Article 31C introduced in 1971, the expanded by the Constitution 42nd Amendment Act, says though the directives themselves are not directly enforceable in the court, if any law made be implement any of the directives contained in the part 4th of the Constitution, it would be totally immune from the constitutionality on the ground of contravention of the fundamental rights conferred by the Article 14 and 19. The attempt to confer the primacy upon the directives as against the fundamental rights has, however, been foiled by majority of Supreme Court bench. The Minerva Mills case in two respects. In it has struck down widening of the Article 31C to include any or all of the directives in parts of 4th on the grounds that such a total exclusion of judicial review would offend the basic structure of the Constitution. As a result, Article 31C is restored to its pre-1976 position, so that the law would be protected by the Article 31C only if it had been made the implemented of the directives in Article 39B, C, and any of the other directives included in the Part 4th. It has been held that there is a fine balance in a original Constitution as between the directives and the fundamental rights, which should be adhered to by court by harmonious reading to two categories of provision instead of giving any general preference to the directives principle. It is also be noted that the outside these the fundamental rights in Article 14 and 19, the general proposition laid down in 1951 shall subsist. Thus, by way the implementing the directives of Article 45 to provide free and compulsory education to children, the state cannot be override the fundamental rights under the Article 31 minority communities to establish educational institutions of their own choice. The Supreme Court observed that the directives of principle by state policy have to conform to and run a subsidiary to the chapter on fundamental rights. Nevertheless, determining the scope and ambit of the fundamental right relied on the behalf of any person or body, the court may be entirely ignored. These are the directive principles of state policy laid down in Part 4th of the Constitution, but should adopt the principle of harmonious construction and should attempt to give effect to both as much as possible. It has been held the fundamental rights and the directives of principle are the two wheels of chariot as an aid to make social and economic democracy true.